Good afternoon, distinguished guests, HKU affiliates, and students. Thank you for joining us today. We are incredibly honored and privileged to have Professor Madhavi Sunder deliver a public lecture on intellectual property and public health. She previously presented a Haochen lecture at our law school in 2012. Welcome back, Professor Sunder. Professor Sunder is a towering figure in intellectual property academia. As one of the most original thinkers and scholars in the field, her work has significantly influenced intellectual property theory and policy. Her scholarship is interdisciplinary, straddling private and public law, and engages global dimension of law from patents and access to medicine to trademarks and university brands. Her book, From Goods to a Good Life, Intellectual Property and Global Justice, brings a humanist approach to intellectual property law. The author of over 40 articles and book chapters, she has published in Yale Law Journal, the Stanford Law Review, the University of Michigan Law Review, the California Law Review, the Texas Law Review, and many other leading law reviews. She has been a visiting professor at Yale Law School, the University of Chicago Law School, and Cornell Law School. Professor Sunder is also a leader in legal education. As Associate Dean for Graduate and International Programs at Georgetown Law, she oversaw the largest graduate law program in the United States, with over 700 students and 15 degree programs, as well as the Center for Transnational Legal Studies in London. How could you accomplish that? That was amazing. As Senior Associate Dean for Academic Affairs at the UC Davis School of Law, she founded the first generation ethics program for students who are first in their families to attend colleges and professional school. Please join me in welcoming Professor Sunder to deliver the public lecture.
Yes, I would want to thank the Center for Medical Ethics and the Law program here at Hong Kong University for this generous invitation. Also would like to thank Dean Haoling Fu, who has always been an incredible host. As Professor Sun said, this is not my first visit to HKU or the first time I've gotten to collaborate with the wonderful faculty and administration and students here at HKU. I had the pleasure and the honor of delivering the Haochen lectures in 2012 here, and it is so great to be back. We've gotten to spend almost a week here in Hong Kong and at HKU. And I have to say that I am always so impressed from Dean Fu on to the entire faculty and student body with respect to the intellectual engagement that I have been able to have over a number of years now with all of you here in this community. And also, there is nobody who can rival HKU for being such gracious hosts. So thank you so much. I must thank, of course, above it all, my dear friend, co-author, co-editor, collaborator in so many projects, from luxury brands to university brands, now to also the pressing issue of patents and public health that we are addressing in our new co-edited volume together that I'll be talking about today. Thank you so much, Haochen, for just being a great intellectual friend and colleague for more than a decade now. I'm so grateful for that. So Hong Kong has come out brilliantly. I'm seeing this city sparkling this week after one of the longest shutdowns across the world, really, due to the once in a century COVID-19 pandemic, and in particular the COVID-19 pandemic. And really, there is sadly no better example to demonstrate the topic of our book, which is that protecting intellectual property is a question of life or death. We can forget this. I know that Professor Sun, in his many hats, just hosted an incredible conference here on data protection and AI. And, there's lots of contemporary debates all around copyright and whether AI is in copying the world's knowledge is whether this is fair use or not. But we cannot forget the really important lessons that we saw demonstrated in such stark terms during COVID-19. And there are a number of stories to be told here with respect to patents in public health during the COVID-19 crisis. We saw that, in fact, intellectual property was a critical part of great success in combating that once-in-a-century pandemic. So COVID-19 vaccines were partially incentivized by intellectual property, and they're estimated to have saved nearly 20 million lives worldwide during, in particular, the critical first year that the vaccines were made available in 2021. While the development of COVID-19 vaccines is a success story for intellectual property, the distribution of those vaccines, again, particularly in the first year of the vaccine's availability in 2021, was anything but a success. And in fact, I think we will demonstrate that it was a gross failure. So while most of the benefits of this life-saving technology, the 20 million lives saved in 2021, we know now, and we saw this happening all along the way, that most of these benefits went to high and upper middle income countries. Despite 10 billion vaccines that were produced by the end of 2021, only 4% of people in low income countries were fully vaccinated. Of 7 billion vaccines that were administered globally by late 2021, approximately 1 year, again, after the vaccines were developed, over 70% of those jabs had gone to high-income countries. In low-income countries, including Nigeria, Mali, and Uganda, a mere 1% of the population had been vaccinated a year after the vaccines were rolled out. Even by early January 2022, we still saw only a mere 8.5% of people in low-income countries that had been vaccinated with at least one dose, in stark contrast to 60% vaccinated in high-income countries. So the result of this inequitable distribution of COVID-19 vaccines in 2021 was vaccine apartheid. In a new article in the Harvard Journal of International Law online, Professor Sun and I call this the lost year of COVID-19 deaths. And of course, looking at this vaccine apartheid, UN Secretary General Antonio Guterres memorably graded the abysmal failure, saying, "We passed the science test, but we received an F in ethics." So even still, the role of IP in this story is hotly debated. So pharmaceutical companies highlight the role that IP played in incentivizing the development of COVID-19 vaccines, while downplaying IP's role in mediating manufacture, access, and distribution. And many important questions are raised. Is IP's role merely just limited to developing breakthrough drugs, but not their distribution? We readily accept IP's goal to promote efficiency, but does IP also have a role and an obligation to promote equity? So today I want to emphasize that we must pay attention not only to incentives for development, but also to issues of distributional justice in IP law. While the development of COVID-19 vaccines is a success story, with respect to development, although I will complicate that story in today's lecture, the distribution of COVID-19 vaccines is not. Paradoxically, and we demonstrate this in our new volume that is co-edited to be coming out very soon this year from Cambridge University Press, intellectual property may indeed also be partly responsible for hundreds of thousands of lives lost in 2021 due to insufficient supply of vaccines and inequitable access during that crucial first year of vaccine rollout, most notably in low-income countries that lacked the ability to buy or manufacture vaccines to save their populations. A mathematical modeling study that was published in The Lancet in September 2022 found that 45% of deaths in low-income countries could have been averted if just 20% of the most high-risk patients in those countries had been vaccinated in 2021. This was, in fact, this vaccination of just at least 20% of all of the most highly at-risk patients in the world. That was initially the goal that was set by the COVID-19 Vaccines Global Access Facility, or COVAX. But this goal was never met in 2021. In fact, we fell far short of this goal by the end of 2021. And the Lancet study, again published later in September 2022, lays the blame squarely on intellectual property. So the study concludes that more lives could have been saved if vaccines had been distributed more rapidly to many parts of the world, which going forward requires that, the Lancet study concluded, intellectual property must be shared more quickly in the future with more open technology and knowledge transfer surrounding vaccine production and allocation. Of course, IP was hardly the only roadblock to a global vaccination campaign and the pandemic response. The Lancet study, and we in our book, identify many other critical factors, including misinformation, vaccine hesitancy, insufficient vaccine donations, and poor distribution and delivery infrastructures. But make no mistake, for better and for worse, in the world's response to COVID-19, IP looms as a central figure. So what happened? And the what happened is exactly the story we're telling in our new book. So in this forthcoming edited volume that I've co-edited with Professor Sun, we bring together experts in intellectual property and global public health from around the world to investigate how intellectual property was both a hero and a villain in the COVID-19 pandemic and its response. As I will discuss, IP is partly, but not wholly, responsible for the rapid development of the successful COVID-19 vaccines. But IP is also implicated in the choked supply of COVID-19 vaccines in low-income countries, particularly during that crucial first year of the vaccine's availability in 2021. So in today's lecture, I'm going to highlight some of the key causes, the diagnoses of what went wrong, as we put it in our book, for the inequitable distribution of life-saving COVID-19 vaccines. And these, basically, three dominant causes. First is the misguided reliance on voluntary mechanisms to share knowledge and vaccines. Second is vaccine nationalism. Third is the unequal global intellectual property institution, namely the WTO, that disenfranchised low-income countries and continued to reproduce a colonial-era dependency by poor countries on high-income nations for life-saving technologies. So I'm going to outline these three causes of the inequitable distribution, and the book spends most of its time not just diagnosing what went wrong, but really thinking about how can we begin to correct things now so that we will be better prepared and can avoid this gross inequitable distribution in the next pandemic. And so that is the cures. What are the potential cures? And the key reforms, there are a number of reforms that are highlighted in the book, but let me just highlight three that I'll talk about today. First is delinking vaccine development from intellectual property rights, especially when development of those vaccines depends on significant public funding. Two, enhanced legal requirements to share publicly funded technologies in pandemic times. So this would be mandatory rules for sharing and not relying on voluntary sharing by pharmaceutical companies or by high-income countries. And finally, third, investment in technology transfer hubs and local vaccine manufacturing capacity in low and middle income countries. So let's jump into it and begin with the diagnosis. And let's go back to this story of intellectual property's role in the development of intellectual property of COVID-19 vaccines. So the development of revolutionary COVID-19 vaccines has been hailed as a success story. Pharmaceutical companies like Moderna and Pfizer argue that patents and other IP protections in their groundbreaking mRNA technology in particular were essential to their success. The real story of successful development of COVID-19 vaccines, however, is more complex. the timely development of the vaccines was not the result of private companies going it alone, but instead the fruit of critical public-private partnerships between governments and pharmaceutical companies, with governments investing billions of dollars in research and development, clinical trials, and advanced purchase contracts promising to buy hundreds of millions of doses. These investments significantly de-risked COVID-19 vaccine development by private companies, thus qualifying the usual claim by private corporations to monopoly control in their patented inventions. In particular, in the United States, the Trump administration launched Operation Warp Speed in early 2020, and this was a public-private partnership to hasten the development, manufacturing, and distribution of effective COVID-19 vaccines. The Operation Warp Speed program paid $14 billion in taxpayer money to several private companies racing to develop a cure for the pandemic. Operation Warp Speed funds plus additional American taxpayer funding included $1.5 billion for Johnson & Johnson, $1.2 billion for Oxford AstraZeneca, and $2.48 billion for Moderna. So these funds were for research and development, including costly clinical trials and advanced purchase orders. While Pfizer did not receive Operation Warp Speed funding for research and development, it did receive $2 billion from the Operation Warp Speed budget for an advanced purchase order to manufacture 100 million doses of the COVID-19 vaccine for use in the United States when the vaccine was shown to be safe and authorized for use by the FDA. So companies like Moderna also benefited enormously from publicly funded research supported by the National Institutes of Health. Public-private partnerships, in fact, this wasn't really anything surprising in terms of noting this important role of the public funding in the successful and speedy development of the COVID-19 vaccines, because public-private partnerships are, in fact, the rule, not the exception when it comes to vaccine development. As the leading public health scholar and my colleague at Georgetown Law, Lawrence Gostin, writes, quote, the intellectual property system does not generally incentivize companies to produce vaccines or medicines for small or uncertain markets. Developing new vaccines, of course, can cost billions of dollars and take several years with no promise of return or investment, especially for diseases that primarily affect populations in low-income countries. So focusing on cures to the legal innovation infrastructure for pandemics, Professor Gostin makes the case in one of the chapters in our book to, quote, overcome market disincentive through targeted financing and partnerships, unquote. So IP alone has never been enough to incentivize the critical innovation in the vaccine space. And we should be careful in telling the story of the role that it played in the development of COVID-19 vaccines. So this is an important part of our story, because recognizing the critical role of public funding is a first step to understanding the need for increased governmental authority over how these technologies are shared, licensed, and ultimately distributed. A critical problem, of course, is that though COVID-19 vaccines were the fruit of significant public investment, this taxpayer-funded innovation is ultimately trapped in corporate monopolies that allow private companies to call all the shots, forgive the pun, for this technology. So next, I want to turn to the second failure during the COVID-19 vaccine pandemic and response, and that was the failure of rich nations to voluntarily fund vaccine delivery to poor countries, and the failure to of corporations to voluntarily share technology with vaccine manufacturers around the globe to scale up production for doses for low-income countries. So this is what we call the failure of the philanthropy model that really governed the approach during the COVID-19 pandemic. So even before the effective COVID-19 vaccines were developed in late 2020, global health experts predicted that there would be a frenzied global race to procure a limited supply of vaccines and that this would inevitably leave low and middle income countries waiting at the back of the line. In early 2020, Richard Hatchett, who was the director of the Coalition for Epidemic Preparedness Innovations, and Seth Berkley, the head of the Vaccine Alliance, or Gavi, they brainstormed and established what I mentioned earlier, then that is the COVID-19 Vaccines Global Access Facility, or COVAX. And the idea of COVAX was that rich countries ahead of the game would pledge funds that would be pooled together so that COVAX could purchase vaccine doses that would be targeted to low-income countries. The goal of COVAX was to pool these funds and to purchase, in fact, 2 billion vaccine doses that would be set aside to be delivered to low and middle-income countries. If all went according to plan, COVAX would procure enough vaccines to ensure that 20% of the most vulnerable citizens in all countries, including the low and middle income countries, and this is particularly the medical workers and the elderly, that these most vulnerable portions of the population would be vaccinated by the end of 2021, regardless of a country's wealth. Ultimately, however, COVAX did not realize even half of this goal, and low-income countries fell tragically behind in vaccinations in 2021. Rich countries rushed to make advance purchases of shots directly from vaccine producers like Moderna and Pfizer, with some countries like Canada procuring enough doses to vaccinate their population many times over. The well-planned vaccine diplomacy that COVAX leaders imagined gave way instead to vaccine nationalism and hoarding. Companies like Pfizer and Moderna, in addition, which closely held critical knowledge about mRNA vaccine production through patents and tacit knowledge or know-how and show-how about how to effectively and safely make these vaccines, they also only licensed a handful of manufacturers to produce the vaccines. The limited supply raised the prices of the vaccines, and the drug companies catered almost exclusively to wealthy countries and regions, such as the United States, the EU, and Israel. These same companies had no market incentive to ramp up manufacturing for shots for low-income countries who could not afford to pay much more than the manufacturing price. There was little left over from a limited supply of vaccines for COVAX to purchase on behalf of low-income countries. And furthermore, what else, the other thing that we saw happening was that high-income countries did not donate to COVAX as they promised. So COVAX ultimately was left underfunded and undersupplied, and they couldn't compete to secure vaccines. Worse still, leaders of African and other low-income countries were told that they could not seek to procure doses directly from vaccine developers, but that they only could go through COVAX to obtain vaccines. So many have opined on why COVAX failed, but public health scholars Matt Cavanaugh and Renu Singh, whose work we also publish in our book, they have offered a scathing critique of COVAX's demand-side model that's built on private property and market-based tools. So Cavanaugh and Singh blame COVAX's reliance on the status quo concerning strong IP rights for corporations. This market-based approach ignored the public investment in vaccine development and the critical public interest in equitable vaccine access to end a pandemic where no one is safe unless everyone is safe. So from the start, the parties at the table leading the COVAX initiative, including the Bill and Melinda Gates Foundation, insisted that pharmaceutical companies should retain strong IP rights in vaccines, imposing no obligations, no mandatory obligations at all on companies to share their knowledge, and instead relied on the charity or philanthropy of rich countries to pool funds to purchase IP-protected vaccines for the poor, or on private pharmaceutical companies to transfer knowledge voluntarily. Neither of these happened. Ultimately, waiting for voluntary funding by wealthy countries or voluntary sharing of technology by the pharmaceutical companies was in vain. Most notably, because COVAX did not alter the status quo rules of IP, companies like Moderna and Pfizer had no market incentive, nor were they legally compelled to license their technologies to more manufacturers to increase global vaccine supply. The third failure that we identify was the failure of technology transfer and the critical vaccine production of know-how. So the pandemic also demonstrated corporate actors' failure to voluntarily share critical trade secrets that are required to scale up production of vaccines. So notably, even more than just patents, trade secrets in the form of corporate know-how and show-how with respect to how to make safe and effective vaccines proved to be the critical technology at play during the COVID-19 pandemic. So unlike earlier public health crises, such as the AIDS epidemic in the late 1990s and the early 2000s, compulsory licensing of patents, which the TRIPS agreement does address, was not enough in this case to facilitate production of COVID-19 vaccines by generic producers. This was a brand new technology, and the critical knowledge, the know-how, was still held by companies like Moderna and Pfizer. So, but it was not these methods were not easily replicated with just the patented formula alone, but they required the affirmative sharing of this corporate know-how and show-how. But companies like Pfizer and Moderna didn't voluntarily share this IP, despite the creation of a technology access pool, for example, by the World Health Organization, known as CTAP, or with potential vaccine manufacturers in low and middle income countries. The failure ultimately of companies to voluntarily share this know-how and of governments to mandate sharing proved deadly. And in the end, waiting for voluntary foundation funding or donations or voluntary sharing of technology transfer was in vain. So a critical lesson of COVAX and CTAP and their failure is that in the early months of the pandemic, increasing supply of vaccines is only accomplished by compelling technology transfer by companies holding the secrets to making life-saving vaccines. I will discuss proposals for spurring technology transfer of know-how shortly. But let me first turn to the final failure during the COVID-19 pandemic, and that was the failure of institutions, specifically the World Trade Organization. So in contrast to the philanthropy approach of COVAX that would leave IP protections in place, in the WTO, we saw low and middle income countries leading an alternative effort to waive IP rights, to enable global manufacturers to scale up vaccine production to get desperately needed vaccines in Africa and other poor regions. So in response to the exceptional circumstances of the COVID-19 pandemic, South Africa and India submitted an IP waiver request to the WTO in October 2020. Again, well in advance of the effective vaccines even being developed. The waiver proposal was unprecedented in the history of IP protection because it was intended to trigger a moratorium on protecting IP rights, including copyright and related rights, industrial designs, patents, and undisclosed information, which could include things like trade secrets, know-how, and show-how. Once adopted, the waiver would remain until widespread vaccination was in place globally and most of the world's population had developed COVID-19 immunity. In their submission, South Africa and India asserted that IP rights were a major cause of the manufacturing and supply problems with respect to vaccines, as well as other technologies. While some countries were in a position to overcome supply issues by manufacturing their medical products, many developing or least developed countries, LDCs, were not, and therefore would remain extremely vulnerable without the rapid scaling up of global production. Therefore, they argued that an unprecedented solution was needed in that time. And in fact, initially, world leaders, policymakers, and scholars had high hopes for the IP waiver proposal, with more than 120 countries supporting it as of May 2021. Most notably, American President Joe Biden issued a statement that same month outlining his support for the proposal. Despite widespread support, however, the European Union and Big Pharma vehemently opposed the IP waiver. A much smaller group of high-income countries contested that IP played any significant role in stunting the manufacture and distribution of vaccines in 2021. At a TRIPS Council meeting, the EU asserted that, quote, there is no indication that IPR issues have been a genuine barrier to COVID-19 related medicines and technologies, unquote. Pharmaceutical companies acknowledged that IP protection has been important in incentivizing them to develop the vaccines, but they disputed that IP had any role in the failed distribution effort. In June 2021, the EU submitted a counter proposal, and this counter proposal was quite different from the initial proposal of South Africa and India, because they really did not allow for any waiving of any IP rights whatsoever. The counter proposal by the EU merely sought to reiterate existing WTO rules, largely with respect to exceptions for and limitations for patents, but not addressing at all the trade secrets or know-how and show-how that were at issue. So ultimately, the ministerial conference adopted the ministerial decision on the TRIPS agreement in June 2022, after more than a year, almost a year and a half of debates about this waiver. And this decision, of course, officially tolled the death knell of the IP waiver proposal, because it doesn't waive the implementation of any IP provisions under the TRIPS agreement. So let's turn to thinking about what can we do better now moving forward, right? What are some of the cures to the key challenges here, which is largely focused around both the failure of voluntary mechanisms to share doses, to share funding, but also the failure of voluntary transfer of technology and know-how and show-how by the pharmaceutical companies. So in particular, in our new book, we recommend a number of potential cures, and let me just highlight a few of them here. First is strengthening technology transfer mechanisms, particularly focusing on moving from this voluntary mechanisms to mandatory mechanisms in particular ways. Some of these would include, for example, modifying the patent system to require greater disclosure of tacit knowledge and know-how related to the manufacturing of vaccines. Another would be placing knowledge transfer obligations on patentees who receive significant public funding through ex-ante contracts. And another is strengthening Article 66(2) of the TRIPS agreement to ensure that developed countries fulfill their obligations to promote technology transfer to least developed countries. Another category involves establishing a global mechanism for monitoring and assessing technology transfer. And finally, focusing on fostering local manufacturing capacity. So investing now the funds and the technology sharing that's required to support regional technology transfer hubs, in particular in Africa. So let me just say a few words on these. So first, with respect to technology transfer mechanisms, again, I think our book is fantastic. I highly recommend that you look at the individual chapters from our contributors. But one important recommendation focuses on potential modifications or reforms to patent law itself, comes from Professor Peter Lee. He has described the current paradox, right? That though patents are premised on a quid pro quo in which inventors receive exclusive rights in exchange for disclosing novel information, disclosure rules currently exclude from protection tacit knowledge. This includes the know-how and the show-how that we saw was so critical to allow for scaling up production in the context of the COVID-19 vaccines. So Professor Lee suggests modifying the patent quid pro quo to require greater tacit knowledge disclosure from patentees at the time of obtaining the patent. For example, by resurrecting the best mode requirement and imposing an ongoing requirement to disclose information related to commercializing technologies, particularly for vaccines. Many of our contributors suggest also that public institutions should place knowledge transfer obligations on patentees receiving significant public funding. Again, this is what we saw going back. It's delinking where there is significant public funding. So Sapna Kumar and Anna Santos-Rutschman, for example, propose an ex-ante approach, arguing that governments and non-governmental funders should integrate pandemic planning into contracts used to fund medical research, for example, through what they call dormant licenses that would be triggered in the event of drug shortages in a pandemic. The licenses would require recipients of public funding to assure that any resulting drug will be made available in sufficient quantity and accessible prices. Recipients would also agree to share technology and know-how to a qualified third-party manufacturer in exchange for payment of royalties. So Kumar and Reuchman argue that by acting proactively, governments can reduce drug shortages during future pandemics and save lives. Still others, like David Levine and Josh Sarnoff, argue that many mechanisms actually already exist to allow governments to compel trade secret holders to share know-how in public health emergencies, including the Defense Production Act in the United States. Levine and Sarnoff argue, however, that the primary obstacle to mandatory disclosure of trade secrets was not the law and is not the law. It is rather political will. Acknowledging that reality, they advocate for reasonable compensation to trade secret holders for compelled disclosure to promote access in some cases. In addition, they propose that sharing trade secrets may be encouraged with legislative nudges and incentives. Other experts like Kavanaugh and Singh advocate for internationally binding commitments to share know-how, including mechanisms to encourage compliance with a built-in expectation of national self-interest. So really, in short, as we prepare for the next pandemic, the most important lesson that comes out of the many contributions in the book is that we must acknowledge that voluntary sharing doesn't work. And instead, we need mandatory legal rules to share technology, and that this is critical. And yet another key suggestion, and this is one made by Professors Sun and myself, is establishing a global mechanism for monitoring and assessing technology transfer. So Article 66(2) of the TRIPS agreement says that it is a mandatory requirement of that developed country members shall provide incentives to enterprises and institutions in their territories to promote and encourage technology transfer to least developed country members to enable them to create a sound and viable technology base. So there is an affirmative and mandatory obligation to help build capacity in low-income countries. That said, there has been no monitoring or assessing of this, and really this has been a provision that has lacked teeth. So we are arguing for ways to bring more heft to this really important requirement. And that brings us finally to the last critical recommendation, which is that we must focus on moving away from the deadly dependence model that has proved a failure in the last pandemic. The reliance of much of the global South on imports proved deadly. Going forward, we must move from a dependency model to build capacity for local vaccine production in critical regional hubs around the world, including Latin America, Asia, and Africa. And in their contribution to our volume, Professors William Fisher, Ruth Okediji, and Padmashri Gail Sampath outline a multi-step strategy to foster local production capacity for vaccines and pharmaceuticals in the global South. Their strategy includes things like building domestic legal infrastructure to regulate and support local drug production, government purchasing of medicines and vaccines, technology transfer through apprenticeships with global pharmaceutical companies, robust quality control, and capitalizing on the economic and political power of regional economic communities in Africa, Latin America, and Asia. In fact, efforts have begun to establish WHO-supported technology transfer hubs in key locations in Latin America, Asia, and Africa. The African Union has set a goal to build capacity to locally produce 60% of the continent's vaccine needs by 2040. This is a hefty goal because Africa currently imports 99% of its vaccines. The WHO is supporting an mRNA technology transfer hub at AfriGen in Cape Town, South Africa, and the hub has had significant initial successes. However, critical challenges going forward are in securing finances for the hubs. And in addition, the WHO is struggling to raise the significant finances necessary to establish other planned hubs in countries such as Brazil, India, and Nigeria. In the meantime, access to critical mRNA know-how held by Moderna and Pfizer continues to be elusive, as these firms have thus far failed to offer significant support to these initiatives. So the US and other developed countries must give robust financial and logistical support to regional tech transfer hubs in Africa and elsewhere now. As Laura Pedraza Karina explains, yet another contributor to our volume, quote, know-how transfer, in particular when new countries are involved, is notoriously tricky and requires learning by doing that can only happen through immersive training through, for example, regional tech transfer hubs. Countries such as Indonesia, Thailand, and Vietnam are some of the only lower income countries that are now producing COVID-19 vaccines, she writes, because of the positive spillovers of having participated in an influenza vaccine technology transfer program spearheaded by the WHO in 2005. So it was the earlier technology transfer program from 2005 that enabled these manufacturers in these regions to be able to successfully produce COVID-19 vaccines now. So critical investment in technology transfer hubs in diverse regions in the global south is needed, so countries can build their knowledge and capacity now for success in future pandemics. So let me conclude so we can have some back and forth. It's time to revisit the toxic marriage between IP and health, in sickness and in health till death do us part. The trade-off breakthrough innovation in exchange for monopoly rights that raises prices and keeps critical know-how under lock and key does not work in pandemic times. Vaccines, the workhorse tool for saving lives and ending a pandemic, are often the result of public-private partnerships, as markets alone do not sufficiently incentivize these investments. Given significant public investments in vaccines, it is not appropriate then that this underlying know-how should be trapped in private monopolies, with pharmaceutical companies calling all the shots. Sharing life-saving technologies underlying pandemic vaccines is critical to boosting vaccine production and promoting equitable access to vaccines in a timely fashion. Developing legal mechanisms for mandatory technology transfer in publicly financed vaccines is critical now to help build local manufacturing capacity in the global south, so low and middle income countries are not again trapped in a state of dependence on the charity of the global north. In a global pandemic, no one is safe unless everyone is safe. Equitable vaccination is also key to stemming new variants and promoting the global economy's well-being. As late public health experts Paul Farmer and Sister Simone Campbell wrote in May 2021, only a people's vaccine that is accessible to all will end pandemics. Thank you very much. I look forward to your comments.
Thank you so much, Professor Sunder. What a wonderful lecture. All the stories and thoughts you shared, I mean, the stories that you shared earlier really sound like yesterday. And what happened, for example, in early 2020, in 2021, we experienced through these sad stories, and I believe that what you shared with us just now resonate with our audience a lot. And in December last year, Professor William Fisher actually delivered a similar public lecture here in this venue. So he also shared a lot of information about how we could, promote the role of intellectual property in advancing public health. So I'm so glad that we have joined him in not only establishing the so-called Patent X course with the World Intellectual Property Organization, but also coming up with with an added volume present as you have already showcased so many useful thoughts about dealing with the COVID-19 pandemic as well as a future pandemic. Although I hope that there will not be a future pandemic, but it's kind of inevitable, right? As history has already shown. So thank you so much.